Hi, everybody, and welcome to ZTV Live. Today is Wednesday, December 9th, 2020. I'm so pleased to have you all joining us tonight. If you would, everybody just give us a little wave hello and let us know that you're out there. And please send us any questions you have for our wonderful guest tonight, the host of his own show, Legal Matters. I present to you Mr. Paul J. Dean. Hi, Paul. Welcome back to ZTV.
Hi, Susan. Good evening, and thanks for having me. It's great to be here.
Well,
Happy holidays.
happy holidays to you too. Happy Hanukkah. That's about, I believe, begins tomorrow night. And Merry Christmas is right around the corner as well. And then Happy New Year. How happy are we all going to be to ring in a new year this year?
Goodbye to 2020. I think we're all ready to see that go away.
But bye. You betcha. I know I am. That's for sure. So I know that tonight's topic was going to be of interest to a lot of people in the area. It's the importance of estate plans, and especially for parents with young children, with minors. But I think before we were going to get into that, you wanted to bring up a special community drive that your law firm is sponsoring. Can you talk about that?
Sure, yes. Thanks, Susan. I'm very excited. Our law firm this year is sponsoring a food drive for the benefit of United Community in the Mount Vernon area. And so we're collecting food, canned goods, dry goods, or other necessities such as diapers, baby wipes. There is a list on the website and on our flyer that you can check out. And so if you have items that you'd like to donate, it'll be spread to the needy families in our community. Please drop that off at my residence. The address is 2604 Londonderry Road in Stratford Landing. We've got a bin outside that you can make your food drops, and we'll be delivering those. We'll be collecting through December the 20th, and so we encourage everyone to, if they have some things they can spare, to help make a little bit better holiday for again some of the less fortunate families in our community. And there's also an opportunity if you want to donate cash proceeds that will be used by United Community to purchase and supplement the donated goods. You can do that through the link.
Terrific. And I just posted that link for our viewers. I just posted the link in the comments. It's a little bit long, but it'll take you right to the donation page for UCM. So thank you, Paul, and to the law offices of Paul J. Dean to do a community effort like that. Every little bit really helps and goes so far. There's so many people in such need right now too.
Absolutely. I'm happy.
Yeah. And speaking of a lot of those items, I noticed that there were a lot for families of young children. So let's go right into something. This is something that we can't obviously donate to UCM, but families with minors should. A lot of them probably think, well, I'll worry about planning my estate. What's my estate? What do I have? I own a house down in Alexandria, but that counts, right?
Absolutely. So. I was kind of inspired to talk a little bit about this topic, Susan, because it's so very important, and it's really kind of at the forefront of the minds of parents when they have children. Obviously they want to make sure that their future is secure, but so often I come across parents, especially of young children, who just haven't gotten around to doing a will or a trust, or really kind of dove into the estate planning part, because maybe they're at the beginning of their career and haven't quite accumulated a lot of assets to the extent that they might think that they need some sort of complex estate plan and things like that. But the one thing that people want to do is they want to make sure, first and foremost, what's going to happen to my children if, God forbid, both of the parents pass away while they're still minors. And I think most people really understand that they should designate, someone to be the guardian of their minor children. But I don't think a lot of people really understand sort of what that entails, how to go about, properly designating the right people, but also how to protect their assets to make sure that the money that they're leaving behind is being properly used and designated for the care of their children. So this is something that I engage in very, very frequently. As you know, I have minor children myself, and a lot of my client base comes from people in the community that I've gotten to know over the years through our kids, whether it's at school or out at the ball field or what have you. So this is something that comes up very often, so that's what I guess inspired the topic this week.
That absolutely. I just showed us a slide on the screen 1 second ago. Let me put it back up here. And you're talking about choosing a custodian or a guardian. And this struck me. Your first one, it said plan for today. And actually your second one also, and I want you to talk about these. And the second bullet point said be decisive. Can you talk a little bit more about why you chose those two kind of aspects to emphasize?
Absolutely. So plan for today. So this comes up all the time. People try to look ahead into the future and kind of predict where they'll be at the point of needing estate planning devices to come into action. So a lot of times when trying to decide who's going to be the guardian of your children, some people shy away from naming, people that might be, too old, for instance, in their opinion, at some point down the line. So the common scenario is, well, should I name my parents the guardians of my children? And most times, when the children are very young, the answer is yes. But some people are hesitant to do so because they're worried that, 10 years from now or something, maybe my parents are too elderly and may not be the most suitable for the position. Or they're looking at, other people in their family that might, not be married yet, or, might have a different situation at home. There are all kinds of scenarios, and life's very unpredictable. So we always recommend that plan for what happens if something happens to you and your spouse, or, the other parent tomorrow. Who would be the most suitable person to watch your children and to act as their guardians the very next day if, God forbid, something should happen? Because these estate planning, remember, is always flexible. If something happens 5 years from now, if your guardian moves away, or you have a falling out, or divorce or death, or any of those kind of scenarios come into play, you can always go back and update those provisions of your will or your trust. So I wouldn't be hesitant to go ahead and make that decision, based on sort of today.
Yeah, that makes a lot of sense. Can you put something in a will when you just when you're designating the guardians and you're thinking, okay, let me plan for today in case something happens, but can you put something in the will that says, in 5 years, can you, I guess you can really put anything into your estate plan that you want, right?
Yeah, you can certainly do that. We build contingencies into wills and trusts all the time. So a common scenario there might be if you have siblings, and you have let's say you have a sibling that's 18 right now, and then or a child that's 18, and then you have another one that's 10, and then you're thinking to yourself, okay. My sister or my mother might be the perfect guardian, but really at the end of the day, we would like the older sibling to care for the younger sibling. They're just not old enough yet. So you can build in a contingency that says, my mother is the guardian, until my older child reaches the age of 25 or something like that.
Right.
For example. So yeah, and you can do that really for any role. All the time, because a lot of the folks that I do estate planning for have, minor children or young adults who might not necessarily be old enough to either inherit a large estate or be able to serve as an executor or power of attorney, anything like that.
Right.
Oftentimes, we name someone else to serve that role until the child reaches a certain age, whether it's 25 or 30 or something like that,
Right.
and then they can take over.
Right. And the other point was be decisive.
Right.
Was that,
So this happens all the time. A lot of times they'll sit down with a couple, and they might not necessarily have thought through who they want to name as the guardian of their children if something happens to them. And so instead of trying to sort of settle on one primary person, they'll be tempted to sort of name multiple people. So they'll say, I name as the guardian of my child, Ann and Joe Smith, and also, two other people, another couple from the other side of the family, and it gets into a situation where, it causes confusion if that arises, and could also lead to court battles.
Which is the very thing they're trying to avoid in the first place by
Exactly.
designing an estate plan.
Exactly. So, a lot of times they'll want to name both partners in a married couple. So I name my sister and her husband. Well, what happens if for some reason the sister no longer is alive? Is it her, your brother-in-law that you want to take over as a single dad, or do you want that to be someone else?
Right.
Sometimes it is, sometimes it isn't. But you should say, you should have a single primary person, person A, and if that person isn't available, person B, and so on and so forth. So certainly, you want to avoid any kind of confusion and not leave room for debate or discussion down the line, because if you're lucky, more than one people might come forward and want to serve as the guardian of the child. Want to make sure that you're very clear and precise.
Yeah. Thank you for talking that out. You also mentioned before, and I'm going to throw the slide up here, you mentioned safeguarding your assets.
Right.
And that is usually one of the reasons why you craft a will, is to safeguard your assets and decide where they'll go if you can no longer make the decision, right?
Right, absolutely. So this is really a critical part of the estate planning process when you're dealing with minor children. I think most people sort of, understand that they need someone that's going to watch over and care for their children, but what they also don't understand is that children, as minors, cannot legally inherit assets. So, you can't have a child all of a sudden sitting on $1 million that's theirs. It's just not it's not legal. So a lot of people will go in their wills or in their trust, or particularly in their beneficiary designations for like their life insurance or their retirement accounts or pensions, any of those sort of transfer on death assets. A lot of people make the mistake of naming a minor child as a beneficiary, and then if something happens and the minor child, next thing you know, you're having a fight with the administrator of that plan, and if you don't have some sort of vehicle set up to kind of create a trust to accept those monies on the child's behalf, you can run into a lot of problems.
Right.
So what we want to do is make sure of a couple of things. First of all, anytime that you put together an estate plan, we're going to set up, if you have minor children, some sort of mechanism so that those minor children can have your assets that now your children have inherited are set aside in a trust, and making sure that they're used exclusively for the benefit of the child until they reach the age that you want them to inherit the full ball of wax, so to speak. So, this comes up a lot of time. You always hear these scenarios of the, well, really, and one of the first things is people underestimate their assets upon death. So, I talk to people all the time who are like, we really don't have much money, so
Right.
it's not that big of a deal. But then we start talking about, okay, what kind of equity do you have on your home? Do you have a life insurance policy? Do you have a 401k? And you start adding all of those things up. The next thing you know, you look up and, hey, I might have a $2 or $3 million estate upon my death. And then next thing your son Teddy there is sitting on, a pretty big pile of cash that if he's obviously, as we mentioned, under 18, he can't inherit. But what about when he's 18 years old? Do you necessarily want an 18-year-old child to have that substantial amount of money?
Right.
Don't lack the maturity. So
Right.
a lot of times we'll set up a trust vehicle that holds those assets in trust until the child reaches age 25, or sometimes we'll do a distribution plan where at age 25 the child will get 25% of the inheritance, and at 30 another 25%,
Right.
and at 35 the rest.
Right.
And that's just to protect and make sure that the funds are being used wisely.
Right. We have an excellent question here from Anita Jo Shiflett. And Anita Jo, thank you so much for asking it. Her question says, how much does an executor or guardian get compensated? And how does one safeguard financial abuse that's disguised as compensation?
Very good question. So it depends on who the executor or trustee is. Oftentimes the answer is they don't get compensated at all. So if you naming as your executor or your trustee a trusted friend or relative, if it's your sister, your brother, your mother, or your best friend, most of the time they are entitled to some level of compensation. But most of the time, really, it's just about maybe just covering the expenses that are involved with the direct, administration of the estate.
Mm-hmm.
Now, you may get into a situation where it might make more sense for you to have a law firm or a financial firm, act as a co-trustee if you don't have anyone that you don't feel comfortable will have the ability to administer the estate. The level of compensation is actually set by law. In the Commonwealth of Virginia, as in any other state, you have to basically do an accounting of the estate, and that has to clear what's called the Commissioner of Accounts. It's someone who's an official of the estate, and there's actually a scale that says that you can only take a certain percentage, tied to the size of the state for the work that you do. So that's actually fairly regulated.
Well, that's a relief. We have another question from our viewer, Marilyn Koposh. Thank you, Marilyn. Appreciate your viewing and asking the question. She says, I've heard there are issues of the guardian, excuse me, using money for the children in a not necessary manner. For example, buying a new car every year to take the kids to school and a new safe car, etc. How can you ensure that that doesn't happen? And I think that you may have touched on that in your other answer, but if you can elaborate a little more.
Right. So there are a couple of things that you can consider in this. First of all, during your lifetime, when you're setting up your estate, if you're concerned that whoever your guardian is might abuse the position that they're in, you can actually set things up so you separate the trustee of the finances from the guardian of the child. This kind of scenario comes up, all the time. I mean, a lot of people say, okay, if my sister's going to be watching the child, she should also be the trustee of the finances. But in other situations, sometimes people want to create that separation to avoid those types of abuses. A common situation, for instance, is if there's been a divorce. So let's say that you've divorced and you have minor children, and your ex-spouse would become the primary caretaker of your children. If you pass away and they're still minors, but you don't necessarily trust your ex-husband or ex-wife to take the assets that you have and use them exclusively for the kids. So you can name someone else to serve as trustee of their assets, and then basically the guardian or the custodian of the child would have to go to the trustee, who would safeguard the funds. Now, if there's a situation where the trustee is abusing their authority, there are mechanisms if the child feels that, if they're old enough, that they actually can go and appoint a guardian ad litem, through the court process. Or if another family member feels like there's some sort of abuse of that trustee position, they can come in and kind of, press that in court and have that person removed as trustee.
Oh, I was gonna say, when the guardian and the trustee are at odds, who decides? I guess a judge, right? Because it has to be brought. It needs litigation.
Yep, you find yourself in family court.
That's why it's important to have a competent attorney to make sure that most of these what if scenarios are kind of laid out and answered, right?
Right. Well, and that's the important thing that we always press upon is, take some time to and spend a little bit of money up front to get all these sort of issues worked out in a way that will avoid not only a lot of pain and suffering, down the line, but will also, avoid a much more expensive ordeal when you get involved.
And make sure everything's pretty clear what's needed. Moving on to your next, we had a Mary Wadlin, our publisher, who has a genuine interest in many of these subjects, had a wonderful question earlier, and it's kind of, I was about to ask the different types of trusts. And I know that you had in your presentation, there's a revocable children's trust, a children's pot trust, a testamentary child's trust, and a uniform transfer of minor act trust account, which is a bowl full of words, which you explain in a minute. But before that, what is the difference between leaving someone a trust and leaving something in your will to them?
So there's a couple of basic differences, and this issue comes up all the time. A will or a trust. A will, for the most part, unless you're creating what's called a testamentary trust within the will, which is what we'll touch on a little bit later. But typically what happens is a will just basically makes outright distributions of your assets to the named beneficiaries. A trust, on the other hand, basically holds those assets in a bank account and can have some level of restriction on the distribution of those assets, whether it's age or if it's conditions like someone needs to have graduated from college.
Right.
The trust can be perpetual, so it can basically be there to sort of provide for someone during their lifetime, but hold on to the corpus of the assets so that it can go and support and provide financial support for future generations.
Mm-hmm. What's corpus?
The body of it.
Oh, okay. You're getting all Latin on me.
I'm sorry.
No, that's good. I was hanging on every word, and then I was like, corpus. What does that mean? I obviously haven't taken a lot of law classes, so thank you for explaining that. So a will is kind of immediate, and a trust can be, it can be much more of a lifetime of distribution, if you will. Okay, so let's get back to these different types of trusts.
Okay, so as we were talking earlier, since minors can't legally inherit assets, within either your trust or your will or whatever estate planning strategy you're using, you need to set up some sort of vehicle or some sort of mechanism to accept and hold your assets and put some rules on those assets so they're held for the benefit of your child. And so there are a few common ones that I've listed here that I can sort of briefly go through. So I'll kind of take them in backwards order,
Sure.
from sort of simplest to the more complex. So the first thing that you have is what's called the Uniform Transfers to Minors Act. And this actually often comes into play if someone just forgot to set up a trust or didn't have a will, but maybe has an executor for a will, or they died intestate, all these types of things. There's actually a state-controlled mechanism that allows someone, whether it's the guardian or you can do this within your lifetime, to basically name a beneficiary and name a trustee, and then that money will be set up in an account and supervised under with state supervision until such time your child reaches it can hold the money into their account until they reach the age 21. So that's the bare minimum, and it's really good that we have that in the Commonwealth of Virginia, because it really kind of helps things and keep things simpler, so to speak. But the disadvantage is, you really can't control much of the assets, particularly in your lifetime. You can't put, whatever restrictions are. It has to end when the child reaches the age of 21. But we always leave that as an option. So each will that I write, for instance, I'll put in, if there's an unnamed beneficiary, that's, under 21, the executor has the right to create, an UMTA account, for simplicity of at least being able to somehow accept those funds.
Okay.
The more common thing that we do is we set up what we call a testamentary trust. And a testamentary trust is a trust that's created in the will itself. So it's not a trust that, for instance, that you would go, set up a revocable trust, and a lot of people just don't want to go through the time or the expense of doing that, and it might not make the most sense for them. But what you can do is put a provision in the will that basically says, children's trust, and this testamentary trust springs to life, so to speak, or is only created if you, the grantor or the maker of the will, pass away before the child reaches whatever age you designate. So for instance, in the testamentary trust, that'll often say, if I die before my child reaches the age of 25, my executor or my appointed trustee, I direct them to take whatever interest vests with that child, basically their inheritance, and put it into a trust account that they'll manage for the benefit of my child, and and then they can use those trust funds to pay for the basic needs, the health care, the tuition, education, all that kind of stuff. And then when they reach the age of 25, 30, whatever they choose, then they get the rest of the funds outright. So that's a pretty simple way to do it. One of the caveats there, and we can talk a little bit, is just make sure if you are doing that, that when you're doing beneficiary designations for things like your 401k and your life insurance, that you reference that section in your will, so that whoever's administrating those plans and your executor knows that those funds, if they happen to be inherited when the child reaches is under the designated age, that they go directly into that trust account.
Okay.
So that's the testamentary trust.
Okay.
The other type of trust that you can set up is a children's trust, and this is often done in conjunction if people want to go into a little bit more detail and provide another sort of layer of protection. So oftentimes, people choose to, in addition to having a basic will, they'll choose to develop a revocable family trust for, during their lifetimes. And within that document, you can create a trust account for your children, where you can basically, designate someone as the trustee for those funds, and then basically each share. If your children, let's say you have 3 children, and that your estate is divided equally between those 3 children, then their share is held in trust to a certain age until they become the beneficiary, and this is how it's managed, and all that kind of stuff, and it goes in detail. Since it's in a trust that's already created during your lifetime, that the assets don't have to go through probate. It avoids some of those pitfalls, but it's also a lot, since it's a revocable trust, it's a lot easier to change and rebalance that plan throughout your lifetime.
Mm-hmm.
And so, there's the child's trust that's created right there during your lifetime. And then there's the children's pot trust, which I list there, which is just like the child's trust that's created in the revocable trust. But in the pot trust, the main difference is, rather than dividing the assets among the children in equal shares. So, in that scenario, we're talking about, child A, child B, child C, each the estate. Well, in this case, they direct the trustee to actually keep all the assets combined into a single pot, so that whoever the trustee is can make decisions on sort of how those assets are spent based on the varying needs of the child. So this is your scenario where, child A, goes in state, but child B goes to, Vassar.
UCLA, yeah, Vassar.
Some expensive school. So it allows the flexibility, but, in other serious situations, maybe one of the children has
health concerns or
anything like that. As parents, we all know that, children cost different amounts of money.
Yes, we sure do. I was going to say that one's a hot potato, the pot trust. And again, really trusting and knowing who you're designating as the trustee, it plays such a big role in deciding which one of these plans is really the best way for your family.
No, the pot trust basically allows the trustee to kind of step into the parent's shoes, and just make decisions, based on the variances in the family.
Wow, there's a lot of decision making on the trustee's part with that option. So
absolutely.
Yeah. But like you said, there's some families need it. All kids are different, and they have different needs, and those needs have different price tags on them, as we all know. So, this is fascinating information, Paul. I really like coming up here. I think there was one last thing that we wanted to things to consider, and I think that let me show the screen here, and one of this is actually, you covered most of this already, separating the role of the guardian and trustee, transferring assets directly to the trust, and this is, I think, the bottom line for your presentation tonight, is that there's really no one size fits all solution.
There's not, and we've got into some fairly complex details here, but my message to parents out there is, don't be intimidated by the process. I think everyone wants to do what's right by their kids, but a lot of times people just don't want to have the hard decisions, or really don't want to think about
the unthinkable,
where their children, their children are minors at the time of their deaths. But it doesn't have to be a very difficult process. We can sit down and put together a simple will with a testamentary trust in it for pretty easily, pretty quickly, and pretty inexpensively. So, I just, again, it's something that comes up all the time, and a lot of don't have regrets down the line.
Yeah.
And just make sure that you're getting that sort of stuff taken care of. And
sure. The regret would be that that it wasn't taken care of, much more than, that it was, or the time that you spent. I mean, it's totally well worth it, just for peace of mind,
Yeah.
which really is invaluable.
Mind and not only making sure that your kids are taken care of, but also the people that are going to play those important roles, that they have clear direction and clear guidance.
Yeah,
And
definitely. Well, that's really helpful. And now, on a little bit of a lighter note, my publisher Mary did notice the lamp on the table behind you.
well, it is the season.
Yes.
It came in a box marked Fragile. It's my ode to the Christmas story.
Yeah, and we love that movie because he won that big prize. And Mary was wondering, would you put that in a will or in a trust?
Oh well, I would put it in either.
It's going with you.
Exactly. Exactly.
Well, that's great. Paul Dean, thank you so much. And as everybody can see on the screen, if you have any questions for Paul, please go ahead and reach out to him. There's a contact form on his website at pjd-law.com, the law offices of Paul J. Dean, Esquire. And thank you so much for coming back for your show, Legal Matters, and we'll see you back here again in January. And that's a date to be decided, but it will be sometime in January, so we look forward to it. I didn't know if you wanted to have any final words, or I think you wrapped it up beautifully.
Just have a happy and safe holiday season, everybody. And thank you again for having me.
Sure thing. Thank you, Paul. We'll see you in January.
All righty.
Okay. Yep. Okay, well, that's going to do it for us for ZTV Live tonight. Thank you so much for tuning in, and thank you for your likes and your questions. And we just love the viewer interaction, and we can answer your questions in real time. It's just a beauty aspect of the show. That'll do it for us tonight. Please tune in tomorrow night at 7 o'clock. Grace Arnold will be interviewing Matthew Robertson of the 13, a unique ensemble choir here in D.C., and in preview of their upcoming show on December 20th. It'll be an online show, COVID compliant, so tune in tomorrow night and really learn what Matthew has to offer. It's going to be a wonderful interview with our own Grace Arnold. So that'll do it for us tonight, and as much as you can, please remember to be the good news in someone's life.